Things are getting intense in the heated legal battle between Blake Lively and Justin Baldoni, and it looks like the situation is rapidly escalating. Blake may be facing a significant loss in court, and Ryan Reynolds is reportedly livid with Baldoni allegedly working behind the scenes to bring him down, handling everything from multi-million-dollar lawsuits to public relations crises and unexpected court rulings. The legal feud began when Blake Lively filed a massive $250 million lawsuit against Baldoni, accusing him of serious misconduct. However, Baldoni wasn't about to back down and responded with his own $400 million lawsuit. From that point on, the situation has only grown more bitter, with both sides clashing in a war of words, while also fighting to win over public opinion. It appears that Justin Baldoni holds the upper hand in this ongoing legal battle. Recently, Blake Lively made a bold move by attempting to subpoena Wayfair Studios, the company co-founded by Alon, seeking 2 years' worth of private information she claimed was crucial to her case. However, the judge swiftly rejected the request, deeming it excessive. The subpoena sought information far beyond the time frame in which Lively alleges Baldoni's defamation campaign began. The court found no valid reason for such a sweeping and invasive demand, dealing a significant blow to Lively's case.
It was Blake Lively hitting Justin Baldoni with a wild $250 million lawsuit him up for serious misconduct. Justin, not about to go down without a fight, came swinging with a bigger $400 million countersuit, accusing Blake of extortion and defamation. He wasn't just ready to play, but went all in on Blake, and now, after months of back and forth, it finally landed in court, setting up one of the wildest legal fights Hollywood has seen in a minute.
It's certainly more, than initial counts of life, and more traditional counts of life. I think we'll see it in a similar fashion.
From the very first moment the court session started, Justin's lawyer, Brian Friedman, came in ready to eat. Like, he wasn't just there to argue, he was there to destroy. And the way Blake's legal team started scrambling was both entertaining and embarrassing. They were shook. You see, when Friedman said that he was going to sue Blake into oblivion, well, based on how he handled court, he meant every word. His lawyers were so rattled, they tried to shut him up with a gag order, basically wanting the judge to ban him from making public statements about
Blake and her team weren't deterred, however, and tried again by modifying their subpoenas. Despite the adjustments, the new requests were still deemed overly invasive. The judge rejected them once more, stressing that Lively had failed to demonstrate a valid need for such extensive access to private information. This marked another setback for Lively, reinforcing the court's stance that it would not permit fishing expeditions into Baldoni's personal and professional life without compelling legal justification.
Breaking news and a big loss in court, Team Delulu. Hello, my friend, Perez Hilton here, the queen of all media, the original influencer, and your #1 source for everything news with us saga. Literally minutes ago, Judge Lyman in New York ruled on the Wayfarer party's request to squash subpoenas, and they got a big win, not a unilateral win, because the goddess of gaslighting did score a narrow victory as well. I've got the judge's ruling, let's go over it together. Alright, Judge Lyman writes, Wayfarer Studios, LLC, Justin Baldoni, Jamie Heath, Steve Sarowitz, the Movie Dust Movie, LLC, Melissa Mason, the Agency Group, and Jennifer Abel moved to squash subpoenas issued to cellular providers AT&T, Verizon, T-Mobile by Blake Lively. For the reasons follow, the motion is granted in part and denied in part.
In an ironic twist, while Blake has been battling for access to Baldoni's private information, she simultaneously sought additional protection for her own privacy. Lively requested an enhanced protection order, moving beyond the standard one that had already been agreed upon. This raised eyebrows among critics, who pointed out the contradiction. She was demanding privacy for herself while attempting to invade Baldoni's.
Lively also argued the Wayfarer parties lacked standing to serve the privacy interests of non-parties, meaning those not directly being sued. So, Judge cites law, don't need to read all of the relevant court cases, and he rules as such. Quote, the subpoenas, the Wayfarer party's phone records, even as modified after the conflict, are overly intrusive and proportionate to the needs of the case. The subpoenas request call and text logs to certain the Wayfarer parties and any other phone number, in most cases from December 1st, 2022 to the present. This request implicates legitimate privacy interests. Even though Lively has narrowed her request to exclude content, calls, or messages, phone records themselves would still contain sensitive information regarding which doctors, psychologists, or even acquaintances the Wayfarer parties spoke to and when. Lively has identified no means to segregate those numbers may have some relevance to her case. Those numbers would have no relevance and would reveal sensitive personal information. Lively thankfully argues that will help identify the larger network of individuals perpetuated a negative media campaign against her.
While Baldoni has been gaining the upper hand, in court, he's also faced personal attacks related to his religion. This has sparked widespread public condemnation, with many rallying around him in support. The backlash has only amplified sympathy for Baldoni, and it seems that public opinion is shifting even further in his favor.
Because both teams agreed that some kind of a protective order would indeed be appropriate for this case to protect confidential information. Now, as we reported, Brian Friedman and Wayfarer wanted essentially a model protection order, which is indeed standard. It's a standard protection order. But on the 20th, which was I think last Friday, Blake's team filed for a slightly modified type of protection order that would include increased protections to third parties. Now, we covered this filing. I told you that essentially what was buried in it was what I would describe as the Taylor Swift clause. I'm just calling it the Taylor Swift clause, essentially allowing the respective lawyers to just deem anything that they want attorney's eyes only, right? So they'd they get a document that, and they're just like, you know what, this one, you can see it, Brian, but it's attorney's eyes only. You can't show that to anybody else. So it's really important that you guys understand this differentiation. Like, we have to distinguish between the two, what a standard court protective order is and what Blake Lively's team is asking for, which is an attorney's eyes only designation. So the standard model one is referred to as a model protective order. The court model protective order is something that they had previously agreed to. It just means keeping some of the material that will come out through the course of a high-profile lawsuit away from the general public, most importantly because it's just irrelevant. Stuff that has no bearing on the legal consequences of the case, but might unintentionally stir the public.